Yeah. Right, thanks. So this afternoon, we've got two witnesses, and we're going to start again with Damien, who's going to share some information on what other states have in their laws or constitutions on bargaining laws as they affect agricultural workers. And then after a short break, we're going to hear from the Vermont Labor Relations Board, the state's equivalent of the National Labor Relations Board. And we talked a little bit about that last time, I think, but we're going to hear directly from the executive director who can tell us all about the work they do. But before we get to that, back to you, Damien.
Great. For the record again, I'm Damien Leonard from the Office of Legislative Counsel. I hope everyone enjoyed their lunch break. And I'll try to keep it light. This is a little denser than the statistics from earlier. So I'll go ahead and put my presentation up on the screen. I handed a matrix out to all of you of some of the sort of defining highlights of the different states' collective bargaining laws. You'll notice that there are a fair number of blanks on there. What I did is I went to their statutes. If it was in the statute, I tried to summarize what was in the statute as briefly as I could for purposes of the chart. If there's nothing in the statute that I could find, I left it blank. So you'll notice for some states, there is very little detail on some of these issues. I imagine it's addressed by case law or something like that, but given time constraints, I didn't have time to go through 15 states case law to try to figure out the ins and outs of all of these things. So with that, we'll pull my presentation
Can I
on.
just have one question?
Sure.
On Maine, you have an asterisk.
Yes, the asterisk is because Maine is did not adopt their law.
Oh, okay.
So the legislature passed the law, but the governor vetoed it. So it's there because Maine is similar in size to Vermont, but otherwise that is not actually the law in Maine. So, okay. So as I mentioned last time, 14 states currently permit agricultural workers to collectively bargain. 13 have done so in statute. New Jersey has done so through its constitution without ever enacting statutes to implement for one sentence in its constitution. So all of that has been done through the courts. So New Jersey is kind of unique and probably not the best example for us to use in terms of how to do it. Maine legislature, as I mentioned just a moment ago, they did pass a bill to permit agricultural workers to collectively bargain, but the governor vetoed it in January 2022. Her veto letter is available on the committee's webpage, as well as the underlying bill. So only some of the 14 states define agricultural employer. Oftentimes they define it with a cross-reference to a federal law, the National Labor Relations Act. They'll do that. If they're using that as their reference, they'll say agricultural employer means an employer engaged in any activities covered within the definition of the term agriculture as used in the National Labor Relations Act. While that is not the most precise definition, it is one you may want to consider because that would clearly set what you're regulating as separate from what the NLRA preempts. So the NLRA preempts everything outside of our collective bargaining laws in relation to everything outside of agriculture, domestic work, and public employees. And so that would clearly put you within the confines of that law. Other states use the Fair Labor Standards Act, the FLSA, because that has a fairly broad definition of agriculture. It's very similar to the definition that's used for H-2A workers. Problem is, it's not clear that that entirely lines up with what federal law may or may not preempt in terms of the state. And then unemployment insurance law was used in one state. I think that's a if I'm going to editorialize, I think that's a poor choice. It's a very complicated definition. The only advantage to it is that it lets employers know if I have to pay unemployment insurance, my workers could collectively bargain. But beyond that, it doesn't line up well with other definitions of agriculture. You could, however, constrain things around being subject to unemployment and then defining what agricultural work is beyond that. But it's just a caveat there is that unless you're trying to make it really clear, you know, hey, I file unemployment insurance and I pay unemployment insurance taxes, therefore my employees can collectively bargain. Unless that's your goal, it doesn't line up well with other statutes. Several states apply their laws only to larger farms, and that term is within reason. We're talking about a small number of employees. So Arizona, it's 6 or more employees who have been employed for 30 days during the past 6 months. So what this will exclude is short time sort of folks who come in on a short contract for a couple of weeks. Colorado is 8 or more employees without any qualifiers. Hawaii is 2 or more employees. So that's basically anytime when there might be a unit of 2 or more people in Hawaii, you could collectively bargain. Kansas is 6 or more employees for 20 or more days in any month in the past 6 months. So it's a little complicated, but basically it means you have to have had 20 days of work in a month from 6 employees in that month. So it looks at if you've got a spike in there, you could have collective bargaining. Massachusetts is 4 or more permanent employees as opposed to temporary employees. So this would exclude seasonal workforces. Maine was just 5 or more agricultural employees. So similar to what our State Labor Relations Act has, which is 5 or more employees. It's just saying, do you have 5 or more employees? One of the complications you're going to run into when you're formulating the bill that you need to include in your committee report is how do we deal with seasonal versus permanent labor? As we saw in the statistics earlier, there's a significant portion of farms in the state that have a seasonal workforce, whether it's exclusively less than half the year, their workers work less than half the year, or a portion of their workforce works less than half the year. And how do you deal with that?
The states, unless it's mentioned, and I guess it doesn't really here talk about part-time versus full-time. So there's a permanent versus something else. But in terms of say Colorado, 8 or more employees, they could all be part-time employees?
Yep, they could. So I didn't find any limitations on the number of hours per week that an employee works. One thing that will happen though, when if you have an oversight body, is when they're determining the appropriateness of a bargaining unit, they may say your full-time permanent workforce has very different interests than your part-time workforce or your seasonal workforce. So we're not going to combine them into one bargaining unit, in which case each unit would have to organize separately and would have to unionize separately, separate votes, et cetera. So those are just some examples. You can do any one of a number of things with that. It gets hard when you start counting hours, especially if you have a fluctuating work schedule. I know with state employees, we don't look at the number of hours. We do look at whether you're temporary or permanent. If you're temporary, you can't collectively bargain. If you're permanent, you can, even if you only work a part-time schedule.
So it would appear that there's 9 states that are silent on this.
Yes.
What does that mean?
So with those states, this is one of the interesting things with those states is for a number of them, agricultural work is simply not excluded from their state private sector collective bargaining law. Or in some cases, their collective bargaining law, they may just have one. And so it means agricultural workers could collectively bargain. It means there's no employer size limit. So it could be 2 or more employees. At 1 employee, it doesn't make sense to unionize, but at 2 or more, there's potential benefits from having a unified voice. It means that in some cases, there isn't an oversight body, so there isn't bargaining unit is determined between the employees and their representative and the employer. So you could end up with a really strange looking bargaining unit. But in those states, it's basically, it all falls within the coverage of the law. So it's all agricultural employers, regardless of their size. So you can have, 100-person farm and a 2-person farm, same law, same rules. And there are a number of states here, particularly, I was going to say there are a number of states like Kentucky and Louisiana, where the law is just extremely vague, without much detail at all. Probably a pretty poor example of something you'd want to put in place. It doesn't create a lot of guidance either for employers or for the employees about what you can and can't do, what is and isn't permitted. You'll see again with the strikes, when we get to that, they are apparently permitted in a lot of states, but then there's a lot of caveats and then a lot of questions about how to deal with that and how that is dealt with in the state. Definition of employee is generally really broad. Generally, it's employed by an agricultural employer or working in agriculture or simply employed by an employer, for states that don't define agricultural employer. The big exceptions are usually immediate family of the farmer. And different states define this differently. Sometimes it's parent or spouse, sometimes it's parent, spouse, or child. New York had a really interesting one. They said 3rd degree of consanguinity. Probably not the language I would recommend using, but there are differences there. Independent contractors is kind of a no-brainer. If you're an independent contractor, you're contracting already to provide the labor. And what it also does, though, is it excludes crews. So employees of a contractor who brings a crew onto the farm from collectively bargaining with the farmer. So they can bargain with their employer, the crew, whoever operates the crew of laborers or workers comes on, but they don't bargain with the farmer. So that,
Damien, so under existing federal law, do workers who are contractors in that scenario have a right to?
Independent contractors are excluded under the National Labor Relations Act as well.
But if they're employed by a
so if they're like a migrant crew of pickers or something like that, so their employer would be whoever runs the agricultural crew and then contracts directly with the farmers.
yes.
So theoretically, they could collectively bargain with the operator of that crew. But they can't bargain with the farmers that they do a short contract for. So supervisors is one that's in some and out of others. This is an interesting one. Oftentimes, if supervisors are allowed to bargain, there's clarity around you can bargain if you don't have hiring or firing authority or things like that. So if you're just supposed to supervise the job getting done in the fields, but you don't have the ability to hire, fire, or discipline any of the workers that you're supervising, states will let you collectively bargain, and then exclude you if you have hiring or firing authority or disciplinary authority. Other states just say if you're a supervisor, you can't bargain. So the next is confidential employees. This is a really common one. If you have access to the farmer or employer's confidential business information, you can't bargain because you have conflict. Guards is one that showed up in a couple of states. I don't know the extent to which Vermont farms employ guards, but it showed up in at least one agricultural collective bargaining law. Tenants or sharecroppers showed up in several states. Again, I don't know the extent to which we have any form of tenant farming or sharecropping in Vermont, but the idea here is basically that you can't collectively bargain if you're leasing the land and farming it yourself. So that gets to how do you determine the bargaining units? Most of the states look to sort of the standard tests, which are the employees that you're proposing to put in this bargaining unit that could unionize? So this isn't the, are you going to unionize or not? It's saying, what's the group of employees that could form a union together? Common interests and common working conditions, or are their interests and working conditions different? So that's sort of the standard bargaining unit test. Arizona added some additions to that, including considering whether, and this gets back to something I mentioned earlier, whether it should be only temporary workers in the bargaining unit, only permanent workers, or it should be a combined bargaining unit. And that could be different from farm to farm. And then California, and this is probably more of a California thing because of the size of some of its farm operations out there. But if you have a farm with multiple geographically separate work sites, should they each be a separate bargaining unit and organized separately? So I imagine this is something if you're, one of the really large California berry farming operations or something like that, where you might own 6 or 7 farms that are under one corporate entity. I don't know how much, to what extent this would even exist in Vermont. So, but those are some other considerations. So there may be unique factors in Vermont that would come into play here. My guess is more likely something like Arizona, where you're looking at temporary versus permanent, because that can affect your sort of the interests of the workers. They may have common working conditions interests, but they may have different interests as far as wages and benefits, et cetera. So how do the unions get certified? 8 of the 14 states permit secret ballot elections that are overseen by some sort of oversight entity, similar to what happens in our state with our labor board. 4 of those 8 states also permit majority sign-up, also known as card check. Majority support, 2 states called it. It's essentially where the petition to form a union or to have an election, if you have a majority of the workers in the bargaining unit, they formed a union without having to go through an election. New York has an interesting twist on this, and that they permit majority sign up in the form of dues deduction authorizations. So if the majority of the workers authorize the union to deduct union dues from their paycheck, they consider that to be a majority support for the union. So it's more than signing a petition. You have to be agreeing to give the union the money. So that was an interesting twist. Our state, as I think all of you know at this point, just passed majority sign up for all of our collective bargaining laws, or most of our collective bargaining laws. There are 2 that don't have it because of the nature of the bargaining unit being a quasi-public bargaining unit where there's public reimbursement, but private employers. So majority sign up wouldn't make sense in that situation. But our state has recently passed that. If you enact a separate Agricultural Labor Relations Act there's no reason that you have to also include majority sign up in that. And so that's something that, you know, the uniqueness of the agricultural workplace may factor into how you want to form a union. Maine, for what it's worth, would have permitted both secret ballot elections and majority sign up. The remaining 6 state statutes are absolutely silent regarding how you certify a union. So there is no oversight body, there is no election provision, and it's not clear to me how you get union certification if the employer is unwilling to recognize the union short of court orders. So.
And about,
With respect to the potential constitutional amendment that's coming, what is it in there that excludes agricultural workers in the event that we subsequently pass something to authorize that? Is it a link to NLRB or is there something
So,
else?
well, with respect to the constitutional amendment, there is nothing in the language of the amendment from last year that would expressly exclude agricultural workers. So let me just pull that up. I just want to make sure I grab the.
proposals.
It needs to go through another biennium. And so last year, the discussion was primarily around the issue of would this allow legislative employees or unorganized public employees to collectively bargain. The interesting thing about it is that the language is broad, and I'm just trying to find it on our website. But the language is quite broad, and it does not necessarily prohibit any. It doesn't prohibit collective bargaining by anyone. It says that all workers have a right to collectively bargain. So just want to get the exact language, but nothing in that would preclude, and I mentioned this in my testimony during the session, a group of workers who are currently do not have a legal right to bargain from seeking to be granted that right. So just pulled it up here. Share screen. So this is the adopted language, which cannot change at this point. This is as it would be. So it says that employees have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their choosing for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety in the workplace. So this language is very similar to what's in New Jersey that resulted in the court decision granting agricultural workers collective bargaining rights. I can pull that language up for you. Ours goes on, it follows an Illinois amendment, and it says no law shall be adopted that interferes with, negates, or diminishes the right of employees to collectively bargain. And so that is that's basically language that prevents this General Assembly from enacting something that would prevent individuals from bargaining. The question about the first sentence is whether our Supreme Court, our Vermont Supreme Court, would end up with a similar ruling to the New Jersey courts, which was that that language is self-executing. So we have a number of amendments on the books that our courts have held are aspirational and not self-executing. They're waiting for the the General Assembly has to actually implement them. In New Jersey, their legislature never implemented their collective bargaining language, which I'll pull that up for you. And then it resulted in a court order basically saying, even though you didn't enact this, we find that this is self-executing and we're going to enforce the language of this amendment, because if we didn't do that, it would render the amendment meaningless. So that language is here. So that provides that persons in private employment shall have the right to organize and bargain collectively. Persons in public employment shall have the right to organize, present to, and make known to the state or any of its political subdivisions their grievances and proposals through representatives of their own choosing. So the court with agricultural workers construed this first sentence, which is very similar to the Vermont language, that employees have the right to organize and join a labor organization for the purpose of collectively bargaining. And then it goes on from there. So there's nothing that stops, if nothing passes in terms of agricultural collective bargaining, but that amendment is adopted, there is nothing that stops agricultural workers from filing a case seeking collective bargaining rights under the amendment. The question is, would our Supreme Court, this state, decide that that one sentence is self-executing, or would they decide that it's only to the extent that it's been implemented by the General Assembly, and that it's really the prohibitive second sentence that binds the General Assembly to not negating or diminishing collective bargaining rights that is the applicable one? And I unfortunately don't have a crystal ball, so I can't tell you how that would turn out.
What would likely would be is there are other statutes that we have that provide regulatory guidance regarding collective bargaining and regarding striking and so on. Do we have a situation in which if that amendment passes without change, there's a possibility that any laws that you have that say you have to have 5 or more people to be able to form a union would go out the window? Because it says employees have the right, and there is no specificity as to how many employees that may mean.
So my understanding from other states that have been enacting that, or that have been working on that law, Illinois in particular, is that they've construed it within the context of the existing laws. There are always guardrails and details that are worked out. They are, as you know, with things like the First Amendment, the Second Amendment, the Fifth Amendment, we end up with the courts deciding if we as the General Assembly have gone too far in, for example, regulating speech or regulating firearms ownership, or whether we're within the bounds of that. So we would essentially, if that amendment passes at the end of next biennium and then it's ratified by the voters and becomes part of our Constitution, the question that you would be facing is, if there was a challenge by potential bargaining unit from an employer that had fewer than 5 employees, would the courts find that our law has been invalidated or restricts collective bargaining in a way that is contrary to the constitutional amendment? And again, I don't know how our Supreme Court would rule on that, whether they would rule that the 5 or more is a reasonable regulation of the right to bargain within the confines of that amendment, or whether they would read it to be too restrictive and say the statute is invalid to the extent that it prevents employees of even smaller employers from bargaining collectively. So what I can say is, in New Jersey, when they construed their amendment, they did it in the context of what does the NLRA provide and what state oversight body do we have available to oversee this. And they They use the NLRA as a sort of a persuasive guidance on how to address the case. And then they delegated the day-to-day oversight of what was happening to the state, what are they called? The State Board of Mediation, which oversees public employee collective bargaining, which has got statutes in New Jersey. And so they task them with overseeing this particular election. It's a unique situation there, just like it would be here, in that other private sector employment is covered by the NLRA. So there's a clear law and guidance there. It's the domestic workers and the agricultural workers who aren't covered, where you start to get into questions of what applies. So, does that answer your question to at least as much as I can get to today?
Thank goodness the attorneys won't unionize.
A couple states have permitted us to, but that's up to all of you.
Yeah.
So, yeah, that's always a funny one. When I started in this job, someone asked me why legislative staff weren't unionized. It's like, well, it's up to the legislature whether we get that right. So, and I'm not allowed to have a policy opinion on that. So, that's just how it goes, I guess. Let me pull back up the presentation. And sorry about that. Certification, dispute resolution. Okay, as you can imagine, with several states being kind of silent on how collective bargaining is going to work, except that it's permitted. And I will say those states have a fair amount of language around when you can get an injunction from the courts, but that's about it. And I think part of the reason why those states don't have more information is because when you have the National Labor Relations Act covering most private employment, there's probably not a lot of activity. And so this is probably a fairly old law from before interstate commerce was so expansive, when you could have local unions for local businesses. And so I think a lot of it is these are just sort of dormant laws. And there's not a lot going on in that area. But of the states that have more detail, 7 of the 14 provide for mediation in differing forms. In some cases, the state can unilaterally step in and attempt to mediate if it's going to have a significant impact. And that's a determination usually made by the governor in concert with the oversight body. 2 of the 14 states provide for fact finding. This is where someone similar to an arbitrator looks at the case, says, these are the facts. This is how you compare to the market around you. This is the bargaining agreement I recommend. 6 of the 14 states provide for arbitration or a ruling by the oversight body, similar to the way our labor board is a final step if the state employees in the state can't agree on a contract. And then 11 of the 14 states appear to permit some form of strike. I say appear because it's hard to tell, just looking at the statutes, the extent to which this right has been curtailed or limited through court actions, sort of construing public safety, health, and welfare. So the right to strike is also often limited. You'll see, if you can read the footnotes, you'll see details on the limits every time there's a footnote next to a strike notation on your dispute resolution in the chart. There's a footnote regarding how they limit it. And anyway, I'll go through the limitations here. So Arizona permits a court to stop a strike for 10 days if the employer agrees to arbitrate. But it also permits the court to issue an injunction stopping the strike permanently. If it would result in the loss of products valued at $5,000 or more. As you can imagine, during harvest season, that's a really easy threshold to hit. And that loss of products, I should say, includes things like spoilage, et cetera. So if they're going to spoil, if they'll be unharvestable, et cetera, they can issue an injunction for as long as they deem necessary. Colorado requires 30 days notice to the oversight body. And then the oversight body notifies the employer that the strike is coming in a month, and then also attempts to mediate the strike or convince the parties to arbitrate to avoid a strike or mediate the dispute. Hawaii requires 10 days notice, and then the oversight body notifies the employer. Kansas prohibits strikes during periods of marketing livestock or during critical periods of production or harvesting of crops. You can imagine how critical, if you were looking at something like the dairy industry, the entire year could be a critical production period. So this may or may not be language that works for Vermont. New York just outright prohibits strikes, work stoppages, and work slowdowns. And that's a really broad prohibition. So there is a sort of soft form of not going on strike, but it's called working to rule or slowing down production, where you make the employer feel the sting, but you're not actually going out on strike. And in New York, at least in theory, a farmer can go to the oversight body and say they're committing an unfair labor practice by slowing down production in an effort to get me to agree to their demands in the contract negotiations. And then the board could order them to go back to work fully and otherwise try to restore the status quo.
Well, the kind of restrictions you talk about crops and the like, are there any restrictions that you've seen other than, say, the absolute prohibition in New York that deals with things like a dairy operation in which regular ongoing milking of cows is essential for the cow's health, and so you potentially damage the animals?
I haven't found a specific reference to that. I think that gets more into the states that have adopted this warning period, at which point the state attempts to mediate or convince the parties to arbitrate. One of the things with those states too is it deals with the issue that was discussed a lot during the last session of what happens when you have agricultural workers who have very limited resources and farmers who have very limited resources. How can they pay someone to mediate by the hour? Well, if the state agency is charged with mediating, that's paid for by the taxpayers rather than by those two parties. But it doesn't, if they fail in the mediation and can't convince the parties to arbitrate, you still have the issue of how do we get those cows milked? Potentially the notice at that point would allow the farmer to make arrangements to try to protect their herd. But this is something where I am again getting out of my depth here. They don't specifically address it in law, but this is something where your advocates may be able to discuss that process and potential safeguards, potential measures and variations. But I think outside of Wisconsin, most of these states don't have as significant a dairy sector as Vermont does.
Representative Chestnut Tangent.
Thank you.
Give your hand up.
This goes way back to the earlier slide. It's just, and I'm confused about if part-time workers, temporary workers organize, especially migrant workers who may be moving from state to state. Would they belong to potentially multiple bargaining units? And
So this is why migrant workers are unlikely to successfully unionize with a farmer if they're moving from state to state and not staying for very long. Just because of the amount of time it takes to do a union drive. You're more likely to see it with long-term seasonal workers and with permanent workers. One of the interesting things, if you look at your sheet on the backside for Oregon, it specifically excludes employees who are employed for less than 6 calendar days by the farmer. And there was actually a challenge to this law in Oregon, saying that was a constitutional challenge to this law in Oregon because it effectively excluded most migrant farm workers from the protections of the law. Because according to that case, the majority of migrant workers in that state worked for a farmer for an average of 5 days or less. And so this had effectively excluded them from the coverage of the law. The law was upheld in Oregon, and I am not intimately familiar with the case. But that was the challenge there, was that this was an unfair, sort of unequal protection of the law here. You were effectively excluding a group of workers from the protections of the law without good reason. But yeah, I think with migrant workers in general, you're likely to have a lot of difficulty getting them to unionize. A difference would be, though, if you have a multi-employer agreement. So if, for example, you could unionize a group of employees with a group of farms, then you have a very different story, because the migrant workers, they may only work 3 or 4 days at each farm. But if those migrant workers who move around Vermont doing certain jobs unionize with all the farms that employ them, then you could have a contract, because there's enough time to organize, bargain, and so forth. It takes a long time to organize a union and bargain a contract in the first place. So if you're only in the state for 2 weeks and then moving on to another state, you're not likely to do it. If you're in the state for 6 months, moving from farm to farm, providing the same services, then a multi-employer contract is possible. So clear as mud, right?
yeah, absolutely.
I did want to go back to my comment on dairy industry. It's worth knowing New York also has a significant dairy industry. And so they have effectively prohibited strikes, which would potentially address the concern that was raised during the session about needing to milk dairy cows daily. Oregon has a really funny prohibition here. And the language is not exceptionally clear, but as best I can read it, it prohibits picketing at an agricultural operation during harvest, except by employees of that operation. So I think what they're getting at here is secondary strikes, where the employees who are members of the same union but work at different operations come and picket that farm during harvest in an effort to generate bad publicity, et cetera. But you can prohibit secondary strikes in other ways, and most collective bargaining laws do prohibit or limit secondary strikes, which are often also used as a way to pressure an employer whose workforce is not unionized to unionize by having, or they were historically, by having union members from other workplaces come in and picket that employer. So the employees of the employer don't have to take the risk. And then instead it's other folks who come in, and there are often, including in Vermont's laws, there are limitations on that sort of practice. It's often considered an unfair labor practice. So last one, Wisconsin, the other major dairy state is 10 days notice. And then the oversight body has to attempt to mediate or convince the parties to arbitrate. Before I move on from strikes, are there any other questions?
Yeah, so just a second ago, you were referencing the New York statute and said something about that engendered a lot of discussion when it was brought forward.
So this past session, particularly the issue of what happens to dairy cows if there's a strike, engendered a great deal of discussion.
Do you know what committee was talking about it?
House Agriculture.
Ah.
So,
I don't think this ever reached the Senate Agriculture.
no, so this was a bill that originated in Senate Economic Development. And it was, the language in the original bill, as it passed out of the Senate, struck the words agricultural workers from the exclusions from the State Labor Relations Act, which would have effectively passed that. And that committee, the bill had come in, and I think we discussed that briefly during the walkthrough, and then the conversation pivoted to the issues of majority sign-up, limitations on the types of meetings employers could have to discuss religious and political issues, and the discussion focused there. And then when it came to the House, it was there was discussion that bubbled up in both the Senate and the House when someone noticed again that agricultural workers had been excluded and started saying, well, wait, what does that mean? Now that we're bringing them under the auspices of the State Labor Relations Act, what impact is that going to have? And so in the space of about a day, I heard from like half a dozen members in each body. And then suddenly the bill was up in House Agriculture, where we had long discussions about the impact of things like strikes on dairy cows, the size of farms, the costs of mediation and arbitration, and how do you pay for that if you're either a farm worker earning a relatively low hourly wage, or a farmer who might be bringing in just breaking even and not able to take on the expense of a $300 an hour attorney to represent you in bargaining, or worse yet, an out-of-state arbitrator who charges $1,000 an hour. And so these were the questions, they sort of bubbled up, I think. So I think the answer is basically the Senate was focused on other issues in the bill. There were it was a very big bill. It was like 3 years worth of collective bargaining legislation in one bill. And then the Senate had focused on other issues. And then when it got to the House, the discussion started in both bodies, and suddenly House Agriculture was there taking testimony on it. So
I'm pretty sure I attended every session of the Senate Ag Committee, and I just,
it never made it to Senate.
that's what I thought.
So,
Okay.
yeah, I think it was one of those things where the discussion was so focused on other things that it slid past unnoticed, which is the benefits of a two-body system where there are multiple chances to look at legislation and ask questions. So,
I just said, one of you. It might be a disadvantage too.
there are benefits and drawbacks.
Yeah.
But this was a major piece, and so ultimately ag workers got stripped out of the bill, and this study committee was formed to look more closely at the issue.
I'm curious, and you may not know, Damien, but are these 10-day notifications to whoever that Wisconsin has one, and I think the previous slide also mentioned that in other states, are they common outside of the agricultural sector?
This is not something I've come across before. That said, I've mostly focused on Vermont's laws. And Vermont, with our laws that permit strikes for public sector employees, typically there's a cooling off period. And so you're already in dispute resolution before you can get to the point of a strike. which is another way to do it, is to mandate that you go to mediation rather than go on strike. You go to fact finding or arbitration or before, a state body to settle your dispute rather than going on strike. So state employees and public safety employees are simply not allowed to strike because of the potential harm to public health and safety. And so for those reasons, we have very prescribed dispute resolution procedures in the statute. For folks who are allowed to strike, municipal workers and teachers, you have to go to mediation first. You have to go to fact finding. You may go to arbitration, you may not. But it's after fact finding, you have to get through a cooling off period before you can actually go out and strike. And so that gives you multiple chances to sort of figure things out before you get to the point where either, kids aren't going to school or a municipality shutting down services. And then it also, at that point, the cooling off period usually involves the fact finder publishing their proposal after a certain period of time. So then the public can see where things stand. And with municipal, there's obviously a great deal of taxpayer interest in the school or the municipal contract. You won't necessarily have that with a farm. That said, there's nothing that prevents you from setting up some sort of alternative dispute resolution instead of permitting strikes. So there are options that are out there. But that's just something to keep in mind. We haven't dealt with this at the state level because we don't really have private sector collective bargaining units that are under state law. So the last piece here, and I see your next witness has arrived. The last piece here is just the oversight body. 3 of the 14 states created a separate entity to oversee agricultural collective bargaining. 7 of the 14 delegated oversight to the existing labor relations oversight entity. In some cases, it's kind of funny. You have the Public Employment Relations Board overseeing agricultural unions as well. And in other states, it's just a generally named Labor Relations Commission or something like that. And then the 3 remaining states have no apparent oversight body. And then New Jersey, as I mentioned, the courts, because there is no statute implementing the constitutional provision, the courts charge the State Board of Mediation, which has responsibilities with public employees already, to also take on those responsibilities with agricultural unions. And then Maine would have delegated their oversight to their existing labor board. So there are different models there. As you've seen with the strikes, and then also with issues of unit determination and certification, the oversight body, however you structure it, can provide those services. For the states that don't have an oversight body, I'm just not sure how that all plays out, or if there is successful union drives in a state where it appears the only option is to go to court to try to force an employer to recognize the union. And that is particularly costly and difficult in general. Just litigation in general can be challenging. So I don't know how that plays out. But that's it for my presentation. I've run you a few minutes over time.
I think so. That clock was fast.
Oh, okay.
Right on time. And we may have started a minute late too, so. Thanks, Damien. Are you going to be?
I will.
In the room? Okay, there you go. Okay.
The staff desk there.
Great. Let's take a short break, and then we'll come back and we'll wrap up with testimony from our existing oversight